Today on the podcast, we're joined by Courtney Hansen. She's a powerhouse in personal injury law with over 15 years of experience. After graduating from UC Berkeley with a dual degree in English and political science, Courtney earned her law degree from Seattle University School of Law in 2010. She spent more than a decade at a defense firm representing insurance companies, where she gained invaluable insights into how insurers evaluate and fight claims. That experience gave her a rare inside perspective, knowledge she now uses to outmaneuver insurance companies and secure maximum results for her clients. Courtney later sharpened her plaintiff side skills at a respected plaintiff's firm before joining Chenaur Injury Lawyers, where she continues her mission of fighting for justice. Today we're going to talk with Courtney about some of the most frequently asked questions for personal injury law. And the first question is, if you get in a car accident, what should you do immediately afterwards?
Yeah. Well, thanks, Rick. I'm really excited to be here. And we see clients typically, fairly soon after an accident happens. And one of the most important things we tell them is, document what happened. Use your cell phone, take photographs of the property damage, of the location of the accident, and exchange information with the other party involved. So you have that. Take a photograph of their insurance card. Obviously, you want to make sure you're feeling okay. If you need any medical care, you're going to want to make sure that you indicate that at the scene of the accident as well. But sometimes, and our clients don't always think about this, but it's really important to call the police and document the fact that you were in an accident. Police will prepare a collision report, and in that report they can issue a citation for fault, and that's very helpful for us in arguing whose fault it was. And then we also want you, when you feel safe later down the day, to go ahead and contact your insurance company and report that you were in an accident. Even if that accident is not your fault, it's important to document that with your own insurance company. Later down the line, they'll be working with the at-fault party's insurance company and kind of arguing over fault. So first in time is important.
And if you're calling your own insurance company, what should you say, or what can you say, and what should you not say?
Yeah. So your own insurance company, and we tell clients this frequently, they're on your side. You can feel comfortable telling them what happened. You're going to want to kind of describe the accident, but I would refrain from telling them any information about how you feel. Are you injured? A lot of times our clients have adrenaline rushing through their bodies immediately after the accident, and they feel fine. And saying something like that, even off the cuff, can be used against your claim, your injury claim, later down the line. So you really want to be high level with that. And that's one of the reasons that it's really important to retain counsel. There are so many pitfalls and off-the-cuff comments our clients can make that are recorded that they just don't know can impact their claim 2 or 3 years down the line.
And is it important for them to retain counsel immediately?
Counsel is not essential, but we view it as very important for a claim. And one of the benefits of having an attorney is when you're resolving your property damage right off the bat, we can identify any claims that you can bring. For example, if your car gets damaged and later repaired, insurance carriers, both your own insurance company and the at-fault party's insurance company, can offer you diminished value for your vehicle. So when your vehicle's in an accident, it loses value. That's something that an attorney can identify right off the bat. We can also set your claim up for success. Make sure you don't say anything that's going to hurt your claim, and identify the steps that you can take to protect yourself and make sure your claim is strong moving forward. So it's highly recommended to get counsel as soon as possible.
Does it make a difference if you get counsel early or you get counsel late?
Yeah, that's a great question. 100% it makes a difference. We see clients occasionally that will have tried to resolve their claim before contacting us. And they made the right choice by seeking counsel, but I see very frequently things that they've done to hurt their claim. So one of the things that, if you're in an accident for the first time and the at-fault party's insurance company contacts you, they're going to take a recorded statement of you, and they're going to maintain that statement to hurt you later down the line. But they're also going to request all your medical records, and clients don't realize that they don't have to provide that information. And that information, including any prior medical history that you have, is going to be used against you. And so we can absolutely repair the damage that's been done, but our clients their claim is going to be potentially put at issue if they don't seek counsel right away.
I think one of the questions that people have when they're thinking about hiring a lawyer after a car accident is, how much money is it going to cost?
Yeah, I think that's a valid concern, and it's definitely something that if this was something I was doing for the first time, I would think, wow, that contingency fee, which, is typically going to be a third pre-suit, seems pretty high. I can tell clients this. I've been a defense attorney for a decade, and then I worked in-house with a major carrier. As a plaintiff's attorney, I am always hiring an attorney to represent me. Insurance companies have methods for resolving claims. They know if you're unrepresented, and automatically you're going to get a fraction of what you can recover without counsel. So what I always tell clients is, I'm here to add significant value to your claim, and you're going to always walk away in a better position even with our attorney fees.
Explain that contingency fee, because I don't think everybody knows what that is.
Yeah. So a contingency fee, attorneys get paid in various ways. So typically an attorney is going to be paid per hour, and that can be very costly for people. And hourly fees essentially prevent the average person from having access to competent counsel. And so the majority of personal injury attorneys in Washington charge a contingency fee. And that just means that we only get paid if we recover for our clients, and we then take a percentage of whatever that recovery is. So I think that's important for potential clients to understand, because your attorney has skin in the game and they're there to fight for you. And we only take cases that we truly believe in, because, we're spending time and effort to recover for our clients. And so that's why we take that contingency fee.
So does that mean that I don't need to bring any money to the table? Like, even if I don't have a lot of money and I want to hire a lawyer, I don't need any money?
That is absolutely correct. So when we take a case, we tell clients, you will not pay 1 cent. We incur 100% of the risk. And so that risk, if we do not recover, is our time, which we frequently have cases for a year or two, depending on how significant our clients' injuries are, but also the costs associated with bringing a claim. And so that those costs can include getting medical records, which unfortunately can be quite expensive. And that's the evidence that we need to support our client's claim. But also, if we file a lawsuit, we have to incur court costs, and then we have to hire medical experts, and they can cost thousands of dollars. And so we incur 100% of those costs for our clients, and we're happy to do that because we believe in their claims.
Yeah. How about the medical bills? What if I don't have insurance?
Yeah. So many of our clients don't have health insurance. And there's a number of ways that they can get treatment while their lawsuit or their claim is working towards resolution. So Washington is one of the states where, unfortunately, the injured party has to bear the burden of their medical treatment until we're able to settle their case. And our firm we frequently will be able to refer our clients out to medical providers that will treat on a lien, meaning they don't get paid until the very end of the case, and that allows our clients to get treatment. But we also help our clients work with their own medical insurance through their auto policy, which is called personal injury protection insurance. That's a way that they can get access to payment for their medical bills as well.
Yeah, and that's a good point that you bring up, both with the personal injury protection, because some people they are reluctant to use their own insurance because they think it's going to increase their rates.
Yeah.
And they feel like the other insurance company should be paying for those medical bills.
Again, had I not been in this industry, I would feel exactly that way. So I was a former regulatory counsel for a major carrier, and I always tell my clients, if the accident is not your fault, the insurance company is prevented from raising your rates. And so if we have a client that uses their PIP insurance, the insurance company is not allowed to increase their premiums because of that. So they should feel confident in using the coverages that they've paid money for. And at the end of the day, while they might have to carry some of those costs initially, when the claim is settled, the at-fault party is going to pay 100% of all their medical bills.
Yeah. And the other thing that I've noticed as well is sometimes when a client is unrepresented, they don't know who to submit the medical bills to, and so they just submit it to the third party or the at-fault party's insurance company, and the at-fault party's insurance company then gets all this information prior to settlement.
Yeah. And something that's important to know is we can recover medical care for our clients if it's reasonable, necessary, and related to the accident. And so a lot of our clients, again, when they try to go it alone, first of all, they're giving full access to all their medical history to the enemy. And the enemy has at their disposal medical doctors that will review these records and argue that they're not related or necessary, and that insurance company won't pay for them. And without kind of the knowledge and know-how and access to medical experts, the average person is just not going to be able to fight that. And again, we see it all the time where clients, for example, should clearly be getting a much, much higher settlement, and the carrier is just taking advantage of the situation.
Yeah. So one of the questions when I was practicing more frequently that I would get all the time is how long will my case take? When will I get money?
Yeah, I think that's a very common question. And I always tell clients, you're driving the bus. So I want to figure out what is important to you. Is it important to you to get the maximum amount possible for your claim? Because that's important to me. I will do whatever it takes to get my clients the most money. Or we have some clients that are like, you know what? It's important to me to settle my case quickly. So first we assess what's important to our clients. But typically for an average case, we want to wait until after our clients are largely done getting their medical care before we submit a claim. Because once you settle a claim, you only get one bite at the apple. So it's really kind of a partnership with our clients on how long it's going to take, but we always make sure they're informed every step of the way.
How much time do I have to settle my claim, like if I didn't want to hire a lawyer?
Yeah. So you have what's called the statute of limitations, and that's 3 years from the date of the accident in Washington state to settle your claim or file a lawsuit. And if you fail to do that, at least with the majority of personal injury claims, you will lose your ability to recover for your claim. So again, it's very important to be aware of that legal requirement, especially if you're waiting to get treatment or conclude treatment before seeking counsel.
Yeah, and we've had this a lot as well, where somebody goes unrepresented for quite some time, and then kind of at the last hour they want to hire a lawyer, and then they have a tough time because nobody wants to take the case.
Yeah. We, in fact, Rick, we have a client that came to us on the eve of the statute of limitations, and we were happy to represent her. But it's always a large risk, because when you go into litigation or you file because you're worried about that statute running, you lose the ability to protect your client from other issues that may arise, that we could have potentially settled their claim pre-suit and not given up their medical history. Litigation, everything is kind of out in the open. And so that's why it's really important to get counsel early, is it's our job to protect our clients during the pre-litigation process.
Yeah, and another one of the issues that we've had in the past is, like, sometimes we can't find the defendant to serve them.
Yeah.
And that's scary too.
I know at our firm we have one of the very best paralegals I've ever worked with, and he can find anybody, but it can be difficult, and we like to give ourselves plenty of time in order to locate them, because typically personal service of the defendant is required, and we want to make sure we do things correctly so we don't impair our client's ability to recover.
Yeah. Okay, here's another question that is potentially the question that gets asked the most is, how much money is my claim worth?
I get asked that question every single day, multiple times a day, and I wouldn't be doing my job if I gave an answer without reviewing all the information. And so I always tell our clients, a claim is based on your injuries and also how your injuries impacted your life, and then the cost of your medical records. And so when we put together a claim, we look at several factors to determine value. And so it's very different. You're not going to get an answer from an attorney, a competent attorney, unless they've reviewed everything. And once we have had the opportunity to do that, we have conversations about value with our clients during that kind of settlement process. We look at jury verdicts that have come out to assess value, but I think oftentimes clients are quite pleasantly surprised by the value of their case. It's typically a lot more than they thought it was worth before they hired counsel.
Yeah, and there's some clients who have done a little bit of research on how to value their claim, or there's like settlement calculators that are out there as well. And those typically take whatever the total amount of the medical bills are, and let's just say for this example, it's like $10,000.
Yeah.
And then they put a multiplier on it and say, well, my claim's worth this times the medical bills, 2 times the medical bills, or 3 times the medical bills, or 5 times the medical bills, whatever the formula is. Is that a good way to value a claim?
No. It's not. And one of the important aspects of hiring an attorney is somebody is going to sit with you, hear your story, and we're going to be able to identify a lot of the ways your life has been impacted that really significantly increases the value of your claim. Just an example, I had a client. He was hit by a drunk driver, significantly hit, but his medical bills weren't that high. He had about $8,000 in medical bills, but he had this lingering, ongoing back pain. So had he done that multiplier, Chat GPT may have told him his claim is worth 30 grand. We recovered $200,000 for him.
Wow.
Because again, your attorney's going to know somebody who's driving impaired, that is a potential risk factor for an insurance company. They don't want that information out in the open. And then we were able to locate an expert that was really able to help explain his ongoing injuries and future medical care he needed. So again, it's not a great predictor of value, and we walk our clients through that all the time.
What if I was partially at fault for the accident, or there's like some sort of issue as to liability?
Yeah.
Can I still get recovery?
Yeah. So Washington is what's called a comparative fault state. So every state has different rules about whether or not you can recover. And in some states, if you caused an accident, or even if you're 2% at fault, you might be prevented from any recovery. Not Washington. And so if our client is, say, 80% at fault for the accident, we can still recover 20% of their damages. We use fault as a helpful tool in maximizing our clients' recovery. And there are certain rules around, at the end of the case, when we pay back their medical records, if they contributed to the accident, they don't have to pay back certain things. So that, again, is when you have someone savvy working for you, you can kind of manipulate those facts to make sure we maximize recovery. But even if you're 50% at fault, we can recover very favorable settlements for our clients.
Yeah, and when I was practicing more often, sometimes those cases that are comparative fault, like 50-50, because of subrogation or paying back those medical bills, they often get waived in a 50-50 situation.
Yeah.
The clients end up with almost as much money if it was 100% at fault. So it's crazy how that works.
It's crazy. And sometimes I tell clients, like, don't focus on the fault aspect. We'll use that to our advantage. And just like you were saying, I've had clients recover net more money with that liability issue than without it. And it doesn't necessarily seem fair, but again, it's just a way that we can use the system to our advantage.
Yeah. Do you think it's been helpful in settling cases and in valuing cases with all your experience with the insurance company?
Yeah, absolutely I do. And I think the advantage comes from the fact that I've litigated thousands of claims. And as an insurance defense attorney, I review claims and I would advise the adjuster. So that's the representative of the insurance company that's going to be able to give payment to the plaintiff. And I know what a claim is worth because I've paid on those claims. And so when I see a claim at the early outset and a great client, ongoing pain, I know in litigation, I've paid X amount of dollars for it. And I tell clients, I know what it's worth and I'm going to get you this settlement. Whereas if you didn't have that kind of insider knowledge, you might undervalue a claim.
What do you think about like a person who is involved in an accident, gets injured, and then says, well, I'm going to try to settle this on my own? And if they would have hired an attorney, so ultimately they end up settling on their own. If they would have hired an attorney, do you think they'd end up with more money in their pocket or less money in their pocket, generally speaking?
Generally, more money, not just a significant amount of additional recovery.
If they hired a lawyer.
If they hired a lawyer. And I think one of the things that we always tell our clients are we're here to add value. And, I've had clients say, hey, I've gotten this offer. And I wouldn't accept their case unless I felt that what they would be walking away with would be significantly more, even when I factor in my attorney fees. And I've withdrawn from cases where I felt that, maybe there was minimal recovery available and I couldn't add that value. We've withdrawn. And that's really important for us is we're here to make our clients benefit from having counsel and not reduce any settlement by our involvement. Working internally again for insurance companies, they will segregate claims into attorney repped and non-attorney repped, and they know if you don't have an attorney, you don't really have the ability to fight the claim and get more money, and they will undervalue your claim. You'll probably settle it for pennies on the dollar.
How important is it to get the right attorney on your case?
Yeah, it's very important. So everybody that graduates law school has a JD, but we're not all made equal. And frequently I tell clients, I didn't feel comfortable and competent until at least 3 to 5 years into my practice in one area. And so you'll have lots of attorneys that are going to want to take your claim, but they don't have the experience to back it up. And the experience really gives us leverage to get the respect of who we're negotiating against. They know we know what we're doing. They're familiar with us. If you have an attorney that doesn't have that same level of experience, the defense attorney or the adjuster knows that they can take advantage of them. And, I've had cases where clients have come and said, I've gone to this competitor. This was my offer. And I've said, I wish you would have come to us because I know we could do a better job. But it's really important to find that experienced counsel.
So when you were on the defense side, if you saw a particular lawyer who was maybe handling smaller claims, would you value that different if it were in the hands of somebody who you knew was a really, really sharp, hardworking experienced lawyer.
Yeah, I would tell claims adjusters we can get the new attorney discount on the value of this claim. One of the first things that we did as a defense attorney was, is this plaintiff a great person? Are they a nice person? Will a jury like them? Secondly, we'd consider, who's their attorney? Is this a good attorney? And there are many attorneys out there that are lazy and not willing to put in the time and effort to really represent clients. And we know that they would take a case for 40% of the value, or because of their level of inexperience, they just didn't recognize what a claim could be with, for example, some experts that will represent a claim. And one of the things that I loved when I joined Park Chenaur is, our trial counsel. He's fabulous. He has decades of experience, and I think the majority of attorneys that we work with have at least 15 years of experience, and you don't necessarily find that at all plaintiffs' firms.
Another question that we get asked a lot is, do I need to go to trial?
Yeah, I get asked that question all the time. And so first, we always tell our clients we have 3 years in order to settle your case before we have to file a lawsuit and actually go litigate the case. And so the majority of claims will settle without having to file a lawsuit. We do file lawsuits strategically for our clients, and that's just because we know we can get more money for them. And so when we file a lawsuit, usually trial is going to be set by the courts about a year later. And so we then have 1 year to settle our client's claim, but 99% of cases are going to settle before our client ever sees a courtroom. And a lot of the hard work in litigation is done by your attorney. And so if your attorney is a good attorney, they have set you up for success, and your involvement will probably just be maybe 10 hours throughout the litigation process. With that said, we always prepare a case like we're going to try every single case. One of the important things to know is that we want the defense attorney to think that we're going to try a case. And so we're going to retain experts right away, no matter how small the case is. And we're going to be aggressive in how we litigate that. And once you set up a case, the likelihood you'll actually see a courtroom is actually going to go down than if you were ill-prepared for trial. We have very experienced trial counsel. I've tried several cases to verdict, and 2 of our senior trial attorneys have tried numerous cases to verdict. And that's important because as a former defense attorney, we would look up through, a search to see if the plaintiff has actually tried a case. That information is public. If they haven't, immediately I would pay less on a claim. So even though it's rare that trial happens, it's important to hire a plaintiff's counsel that has that experience. It automatically ups the stakes for defense attorneys, and you can increase value substantially on your claim.
When you file a lawsuit against the defendant, one of the things that people are worried about is a deposition. Can you explain what a deposition is?
Yeah, a deposition is a fancy, scary word for an interview that's taken under oath. And so I always tell clients, when we file a lawsuit, we're filing it because you know your case the best. You're the one that had to live with your injuries. You experienced, for example, if we're in a car accident, an impact. The defense attorney or the insurance company, they don't know. And so an deposition is their one opportunity to meet our clients in person and really hear their story. So I tell clients, a deposition is not something for you to be concerned about. It's your opportunity to shine, and it's your opportunity to help them understand what you went through. So again, it's just an interview, and we fully prepare our clients for their depositions. I frequently tell clients, you might be interviewed. You're not going to be worried about it because I'm going to fully prepare you. You're going to know pretty much 90% of the questions before they're even asked. And it's only going to highlight your injuries and help us advocate for you.
Yeah. And the preparation of the deposition, I think, is really important, because if a client takes a poor deposition, that can affect the value of the claim, and if they take a really good deposition, then sometimes it could settle.
Oh,
shortly
absolutely.
after.
One of the things I tell clients when I prepare them is your deposition is taken for two reasons. Number one, the defense attorney wants information from you, so a fact-finding mission. But number two, they really want to see if you're going to be a nice, likable witness in front of a jury. Nice people get more money. It might not be right, it might not be fair, but how you present during your deposition is probably 30% of a value driver on your claim. And so I always tell clients, like, no matter how frustrating the process is, put on a smile, because that is going to help your claim so much, is how you present in front of that defense attorney.
Yeah, and sometimes for bigger claims, we've kind of practiced the deposition before going into it, and clients get really nervous even in practice.
Yeah.
And sometimes, like, I know this one case we asked, so what are your injuries? And the client had been going through a neck injury for 2 years and forgot to say their neck was injured.
Yeah.
Just because of nerves.
Oh, it happens all the time. And the good thing about, again, having that competent attorney is during the deposition process, we can also have the opportunity to ask some questions. And we're there to, I always say, bat cleanup for our clients, help them remember, what they're there to testify to, and make sure that they don't miss any important points. And also protect their interests and protect their claim throughout that process as well.
Yeah. And the other part that I think is helpful for practicing is getting asked the very difficult questions.
Yeah.
And giving the client a little bit of an opportunity to think about how to answer that, and then also to be calm in answering it, because sometimes, the questions could be agitating and upsetting.
Oh, yeah. In fact, we recently resolved a case where we took the case from another attorney who got no offer. Mid-litigation, we accepted this case, and we settled it for a couple $100,000. Liability was disputed, and I spent 2 or 3 hours with my client and our accident reconstructionist expert preparing for the tough questions on liability. So when the deposition came around, our client felt comfortable and confident, and it really helped us secure, again, that high value settlement for him.
Absolutely. And sometimes we'll get a case from another lawyer, and they've already done a deposition, and when you read the deposition, you just cringe because they were clearly not prepared for it.
Oh, yeah. And I think when you have an experienced attorney defending you, they will anticipate questions, and attorneys are there to make their case. And so the defense attorneys, savvy ones, will ask somewhat inappropriate questions, and if you don't have somebody to object or really prepare you, it really can be highly detrimental to your claim, because what you say in a deposition, it's going to be used against you should we go to trial. And so it's so important for us to get that testimony right.
Yeah. What are some of the claims that people don't really think about or don't know?
Yeah. So there's a lot of claims out there that you may have, and without a knowledgeable, experienced attorney, you might miss out on. And so one of the things I always bring up for my clients is we represent lots of, minors that may suffer significant injuries. And oftentimes their parents are with them or with them in a car and witness their children get injured. And, I can speak from any parent. That's a parent's worst nightmare, is seeing that. So I have personally recovered close to $700,000 for parents who were not injured, but who looked at their children be injured and witnessed it. And that claim is called negligent infliction of emotional distress. So that anxiety from seeing your child injured, that's a claim that, again, not having that experienced counsel know how to make that claim for you, know to bring it up in the first place, you might lose that settlement. An insurance company is not going to tell you about all the claims that you potentially have. We also have another claim that we frequently utilize, and that's called a loss of consortium claim. So, if, for example, your spouse is injured and you have to go above and beyond your spousal duties for them, you have to take care of all the grocery shopping, etc. We use that as leverage to get that spouse money for, again, what they've had to go through by having an injured spouse.
Yeah, and loss of consortium sometimes um, is a touchy claim because it also includes intimacy.
It does. And I before we bring a claim like that, I always talk to my clients about what it could mean for them, what we have to argue, so they're comfortable with it. Because again, my clients drive the bus and we are there to counsel them. So we're there to tell them, these are your potential claims. This is what you're going to have to feel comfortable talking about. Do you want to make this claim? And sometimes they say, you know what, I really don't. And if that's the case, I might say, hey, defense counsel, should we file a lawsuit, might be bringing this claim. And we have great clients, and I get more money just with the threat and not necessarily having to bring it. But we always want our clients to feel comfortable in the process.
Yeah, I think it's a really underutilized claim, the loss of consortium. I think a lot of lawyers leave a lot of money on the table by not bringing it.
Yeah. I recently had a case that I chatted with you about where one of our clients was very injured and we were going to file a claim. And I thought, you know what, your spouse might have a claim. We ended up recovering $25,000 for him just via a loss of consortium claim, which he would not have been able to recover, again, had we not been able to spot that and really advocate for him.
Yeah. Another one of the most commonly discussed issues is property damage. And we're injury lawyers, so we don't actually handle property damage. But how do you deal with property damage for our clients?
Yeah. So again, I used to be regulatory counsel for a carrier, and one of the things that I had to do was train adjusters on how to resolve property damage claims. So I have an intimate knowledge of the process and the legal requirements that they have. So how carriers handle property damage is heavily regulated by the Office of the Insurance Commissioner and our laws, rules, and regulations. And so we are injury lawyers. That's where we feel our involvement can really substantially increase clients' recovery. For the most part, insurance companies get it right. And so we help guide our clients through that process, but we don't take a fee. So I will talk to my clients like, has your car been repaired? Who have you talked to? This is the carrier you should approach. They're going to treat you better. Let me see your total loss offer and I'll tell you if it's fair. And those are the things that I do as a courtesy to my clients to make sure they're treated fairly. Because one of the biggest issues we have is our clients are injured, but they need their car to get to their job and they need to be, put back in their car as quickly as possible. So that's something we address quickly before we can really focus our efforts on the injury, which is typically a lot more significant, long-standing issue.
Yeah, and sometimes I think clients get confused on who to talk to regarding their property claim.
Yeah.
So sometimes they might call the injury adjuster instead of the property damage adjuster.
Yes. Insurance companies are quite large and every claim is segregated to a specific adjuster. And so clients will often say, gosh, the person that hit me, they haven't accepted fault yet. I know I'm fault free, but they haven't done anything. I always tell clients, go through your own insurance company. They're there to take care of you. You pay them a premium. They have what's called a fiduciary duty to treat you well, whereas the other insurance company doesn't necessarily have that. And the benefit is that, again, your premium will not increase based on an accident that's not your fault. So let your own insurance company help you out quickly. They can then go and collect all the money they paid to you from the at-fault party. And it really alleviates some of the delay and stress of working with an insurance company that really doesn't have your best interests at heart.
So with the property damage, like let's say that the example you were giving, that I can't get my car fixed for like a month.
Yeah.
And so do I get compensated for that?
Yeah. So in Washington, we have the ability to recover what's called loss of use. And so, say your car is damaged, and you again you're without a car for a month. You can either go through your own insurance company. Sometimes they'll provide you a rental, but sometimes they won't. You might not have that coverage. We can recover for the loss of use of that personal property every single day until it's repaired and fixed. Now, it has to be a reasonable amount of time. For example, if your car is ready in a month, but you take a year to have it fixed, that's not reasonable. But those are things that we can utilize to put our clients in the best position. And the insurance companies will not always remind you that you have the ability to recover for those types of damages.
What if it's a car that you really, really like, and you're like, this is my baby. Like, I love this car, but maybe the value of it is less than how much you like the car.
That is one of the hardest conversations I have to have with my client is they say, gosh, this car has such emotional attachment to me. I've had it for 15 years. And I say, I completely understand, but we can only recover what's called the fair market value of a car just before the accident. So sometimes that puts our clients in a worse off position because, their car, which may have been fully paid off, isn't worth a ton of money. And now they're going to have to go out and buy another car. I always tell them, this is not fun, but let us help put more money in your pocket on your injury side. That's where we can really help you use some of that money to maybe buy a nicer car.
How about the situation where you buy a brand new car? Let's say you pay $60,000 for your car.
Yeah.
You're driving it off the lot.
Yeah.
And then you get hit.
You laugh, but I've seen claims exactly like that. So insurance companies in general, the at-fault party, they're going to be responsible for the reasonable cost to repair that car. So say your brand new Mercedes is repairable. It's not significantly damaged, but it is damaged. You know that is going to show up on your Carfax report. So say you got this brand new car, you got it repaired, but now the value is just not what it was. You're entitled to the difference in value between a brand new car right off the lot and a brand new car right off the lot plus an accident. And that's called diminished value. Oftentimes we can retain experts to support that. And for high value vehicles, that can mean several $1,000s more in your pocket that you wouldn't have had, again, if you didn't have counsel walking you through the process.
Let's talk about injury damages and some of the things that we can recover for.
Yeah. So we can recover for really kind of all aspects of how your life is impacted because of an injury. So we can recover for, we call them special damages, but it's really anything you have a receipt for. So think about the fact that you went to the doctor and they charged you cost of medical care. So all your medical bills, we can recover for you. We can recover for wage loss that you've had. So say you had to take a month off and you didn't get paid. We can recover for that amount of money. But we also have clients that had to use 15 days of PTO. They got paid by their company, but they've lost out on their vacation time. We can recover for them as well. That is all recoverable. And we've unfortunately had clients that were so significantly injured that they can no longer do a job that they loved and they have to be retrained, or they're out of work for the rest of their life. That's an unfortunate reality for some of our clients. And through the use of experts, we can recover for their future wage loss as well. And lots of our clients need surgery, or they need medical care for the rest of their life. We can recover for those future medical costs as well. But one of the biggest things that our clients hear about is, pain and suffering. We call those general damages. So things you don't have a receipt for example, inconvenience to your life, the pain you experience, the emotional trauma of an accident, those intangibles, we can recover for those as well.
Yeah. And how do you value the emotional damages or mental damages?
Yeah. So the best answer, the most lawyerly answer is it depends. There is no formula for that. And when we try cases in front of a jury, that's one of the hardest and most important skills to have is explaining to a jury what those general damages are, that pain and suffering. And it really comes from the facts of the person. So every person is different. And we may have a client that broke a wrist and it healed mostly, but say they were a professional piano player. That's going to have a huge impact on their career versus somebody that maybe their, non-dominant hand was injured and they don't really use it. It's going to have less of an impact. So it's very fact specific, and it's really, our pleasure to help work with our clients and uncover how their life was impacted so we can tell that story to the defense attorney.
So what about in a situation where you're not a professional, but you just enjoy doing an activity like snowboarding, and then because of the accident you can't snowboard anymore?
Yeah. I have clients, when we file suit or when we're negotiating, I always say, let's talk about the things you could do before the accident that you can't do, or maybe it's changed. And a lot of clients will say, I love cooking, but my wrist is broken and it hurts. I have to stretch my wrist every single time. They say, that's not that big of a deal to me. And I say, yeah, it is. Every single time you're cooking, you're stretching your wrist. Those are things that I can then communicate to the adjuster and highlight for them that, my client's life is not the same. This may not be a catastrophic injury, but it matters to them, and it's an inconvenience every single day for the rest of their life. And so, it's really spending time with our clients to help learn about them and all the, ways that their life is impacted, spending that extra time with them that really helps us add value to their claim.
Yeah, I remember young in my career, I was at an arbitration, and the injured person could no longer garden. Maybe not permanently, but for the 2 or 3 years following the collision.
Right.
And there was a significant amount of money put on that because that's what she loved to do.
Right. Yeah. And, we have clients that will say it's not that big of a deal, but I can't do this anymore. Or, it's probably too small, but I can't lift my grandchildren anymore. And I say, no, that's a big deal. You mentioned it in your medical records. It's important to you. It's going to be important to a jury. So let's talk about it. And it's really making the clients feel empowered to really think about how their life was impacted and the things that brought them joy that are no longer there or have been impacted by the accident.
Well, thanks for talking to us today.
Yeah, of course.
I think everybody who's going to listen to this is going to learn a lot. And if you need to get a hold of us, Park Chenaur Injury Lawyers, we're in Tacoma, Everett, and Federal Way. And this is Courtney Hansen.
Yeah, thanks so much, Rick. Appreciate your time.
Yeah.